Speeches. I call the Honourable Member Charles Chauvel.
Thank you, Mr Chairman. Mr Chairman, I want to start by saying that when the current legal regime applicable to search and surveillance is compared to the regime that is set out in Part 3, then what the Minister says is right. This is a much better regime. It does call, as she correctly described, for approval prior to the fact, and it's judicial approval. And this is the element that was missing in the matter that was decided by the Supreme Court late last year. It is a shame, frankly, that we didn't manage to get this regime in place prior to that decision, but the reality is we're getting it in place now, and that is something that I think we should all be reasonably pleased about. The matters that I particularly wanted to draw attention to in this part, and I would be grateful if the Minister would have a think about these. First of all, the supplementary order paper in the name of my colleague David Parker, which would continue the process that each of the three Labor SOPs have started, which is to mainstream the protections that appear in the bill to the Serious Fraud Office. And in respect of this part of the bill, the way in which that would occur is that Clause 69 would be applied to the Serious Fraud Office, because the Director of the Serious Fraud Office would be, for the purposes of the Act, an enforcement officer who'd be entitled to apply for a production order. And so just as we've begun to build in, or attempt to build in, the Serious Fraud Office right from the beginning in the interpretation clause, so that exercise continues in a necessary clause in respect of this part. The other matter that I just want to draw the committee's attention to is one that was referred to by the Minister in her introductory remarks, and it might also be interesting to hear from a member of the Select Committee on this, because it relates to the regime that would be set up by clauses 57 through 61, the declaratory orders provisions. Now, on my reading of the reported back bill, what was originally proposed was a residual warrants regime. So a law enforcement agency would have to obtain a residual warrant if it wanted to obtain evidence relating to an offence, and the agency wanted to use a device or a technique or procedure or activity that might constitute an intrusion into the reasonable expectation of privacy of any person. Now, all that's been struck out by the Select Committee, and it's been replaced with this declaratory orders regime. And I suppose I have some concerns about the way in which this might operate in practice. What would happen is, as the Minister has said, if there's a new type of device that law enforcement agencies want to use, then they can go to a court, to a judge, and seek effectively an opinion about the propriety of the use of that device. But there are some fishhooks, I think, in the regime as it's set out. The application will be made to a judge. Now, a judge is defined now in this legislation as either a High Court or a District Court judge. It's expressly provided in Clause 57.2 that a declaratory order is advisory in character and doesn't affect the jurisdiction of any court to determine whether the activity that was the subject of the order of the court was reasonable and lawful. Well, that's going to put a district court in some difficulty, I imagine, if on some previous occasion an opinion, advisory only, but nonetheless from a higher court, such as the High Court's been obtained, so that if the High Court purports to give one of these advisory opinions in circumstances that are very similar to those that then come before a district court, it's difficult to imagine circumstances in which the district court's going to be or able to feel free to depart from the views that were expressed on the earlier occasion. The other concern about the declaratory orders, Sir, Mr Chairman,
I call the Honourable Member Charles Chauvel.
is really that it's a novel procedure. We have a declaratory judgments procedure in our Judicature Act at the moment where on a set of existing facts it is possible to go to the court and ask for the law to be declared on those facts, but they're real facts, not hypotheticals, which seems to be the situation that this regime contemplates. And we've never put our courts in the position of having to decide on hypotheticals put to them by a law enforcement agency. Our courts generally decide contentious litigation based on real-world facts. Where in the adversarial model does the evidence to contest what is put up by the enforcement officer come from in this envisaged regime? How does the court undergo an adversarial process in order to come to the view that is envisaged it would by this procedure? Why on earth wouldn't we just do what we expect agencies to do at the moment? They get an opinion from the Solicitor General or the Crown Law Office, or on occasion a Crown Solicitor, on the legality of a proposed method of surveillance, and they proceed on the basis of that opinion. I think we're putting the courts in an odd position where we say the courts can pass an advisory view, and it is expressed to be just an advisory view, yet we're not clear in the legislation about any procedure that would have to be engaged in by the courts, particularly where the hearing the other side practice would come from. We say that they would be advisory only, so presumably in real-world facts that came before the court that were very similar to the theoretical position that was put to the court would still be free to come to a different view. If that is the case, then what's the utility of this procedure? Is it likely to ever be used? And what sort of comfort is it likely to be able to give enforcement agencies in the ultimate analysis? So those are the particular concerns that I wanted to raise about this part, sir. I commend the amendments in David Parker's name. I think the general regime that the part sets out is a great improvement as far as protections for our people from potentially unlawful search and surveillance is concerned. But I do wonder whether the declaratory order regime is, in the end, going to be worth the paper it's written on.
I call the Honourable Member Dr. Jackie Bloom.
Thank you, Mr. Chair.